This conference will now be recorded.
Okay, it is 12 o'clock on the East Coast, so we are going to go ahead and get started with our webinar today. Hello, everyone. My name is Jessica Enix, and I'm with the ASA staff, and I would like to welcome you to today's ASA webinar. Before we begin, I'd like to review a few points of protocol so that you'll get the most out of your webinar experience. In order to reduce background noise, please mute your microphones during the presentation. We also ask that you turn off all your cameras so we are only seeing our presenters. If you have any questions during the presentation, please type them in the chat box. There is a bubble at the top right-hand side of your screen. The presenter will address questions as they become available or at the conclusion of the presentation. Please note that today's program is being recorded and will be available on the ASA online website at the end of the day today. Now it is my pleasure to introduce our presenters, Mr. Jim Sinicki and Ed Hermes. Jim Sinicki's practice involves construction and contract preparation, construction law representation and litigation, procurement law and bid protests, general commercial litigation, creditors' rights and other litigation, alternative dispute resolution and appellate matters. Jim is a construction mediator and arbitrator. Jim was the head of Snell and Wilmer's construction practice group for over 15 years, and the firm's construction litigation practice has been recognized as a national top tier one practice for the past 9 years by U.S. News and World Report. Best Lawyers. Jim has been named to Best Lawyers in America 2003 to 2021 in the areas of construction law and construction litigation. The Best Lawyers in America also named Jim Phoenix Lawyer of the Year, Construction Law in 2013, and Phoenix Lawyer of the Year, Construction Litigation in 2018. Ed Hermes is a commercial litigator with Snell and Wilmer, whose practice is focused on complex commercial, tax, property, and construction disputes. His experience includes litigation regarding breach of contract and tort claims, commercial and residential construction disputes, tax disputes and appeals, and disputes involving federal Indian law. Ed has also worked on garnishments, subpoena responses, lending matters, Fair Credit Reporting Act claims, LLC disputes, tort claims, and other general litigation issues, and regularly appears on behalf of his clients in state, federal, and tribal courts and administrative tribunals throughout the Southwest. Having previously lived and worked in Indian country, Ed also advises companies and economic development entities in conducting businesses and creating job opportunities in Indian country. Ladies and gentlemen, please welcome Jim Sinicki and Ed Hermes.
Thank you, Jessica. I'm Jim Sinicki. I'll go first here, and I'm going to just talk a little bit about this webinar. If at any time you have any questions, I don't want to just pontificate for the next hour and 15 minutes. So if you have any questions, put them in the chat box, and Jessica will ask us at the appropriate time so that we can have some dialogue and we can go back and forth and answer the questions that you want answered and why you signed up for this webinar. I'll tell you a little bit about myself first and the firm, and then I'll let Ed talk a little bit about himself, and then we'll get rolling here. My accent, you probably wonder where's he from? Well, I grew up in Pittsburgh. I then went to the Air Force Academy. I then was in the Air Force and was a C-5 navigator, biggest plane in the world. Flew all over the world for about 6 years, 6.5 years. Got out, used my GI Bill, went to law school in Kansas at the University of Kansas. So I have a good basketball team to root for during this time of the year. I then Frank Snell from Snell and Wilmer was a Kansas grad, and they recruited up at Kansas. So they recruited me in 1983. I started practicing down here at Snell and Wilmer. Snell and Wilmer is a large regional firm. We basically have offices all over the Southwest. We even have an office in Washington, D.C. But Ed and I are in Phoenix, but we have offices in California, Utah, Colorado, other places, Portland, and we're opening an office in Dallas. So anyway, we're a big firm, and we're basically in this part of the country. With that, I'll turn it over to Ed, and Ed can tell you a little bit about himself, and then we'll get rolling here.
Thanks, Jim. Appreciate it. And thank you, everyone, for coming today. My name is Ed Hermes. I'm an attorney as well at Snell and Wilmer here in Phoenix, Arizona. Originally from Illinois, grew up on a hog farm out in rural Illinois. So those of you calling in from the Midwest or out east, I feel you're who are buried in snow. I remember that and have moved to Phoenix, Arizona for that exact reason. So I've moved to Phoenix in 1999, graduated from Arizona State University twice now. Once, my prior career, I was a high school teacher up on the Navajo Indian Reservation, and then left doing that to become an attorney. Graduated from Arizona State University Law School in 2013, and been practicing law ever since, and primarily in construction law and litigation, as well as a few other practice areas that you heard earlier. So it's a pleasure to be here today, and look forward to giving you guys this presentation. Please do type any questions you have in the chat. As Jim gets started here, I'll be also checking the chat from time to time to interject some questions as well that you might have. So with that, Jim, I'm going to kick it back to you.
Okay, thanks, Ed. Let's go to the first slide then. And while Ed is getting the slide arranged, Ed failed to mention that he was Sparky at ASU, and Sparky is the mascot at ASU. And if you ever watched Arizona State play football or basketball, you'll see their mascot. So Ed doesn't like to mention that, but I think it's kind of a cool thing, so I brought it up. So let's get started. So let's talk about delay and disruption claims. There's a difference between delay and disruption claims. A delay claim captures the time and cost of not being able to work. In other words, the permits didn't come on time, something delayed the project, and you're not able to work. Well, obviously, if you're not able to work, but you're still out at the project, you're incurring GCs, and that's something that you'd want to try to recover. A disruption claim captures the cost of working less efficiently than planned. And subcontractors know all too well that at the end of the project, where you had planned having 2 subcontractors in a space, there's 9 subcontractors in a space, and obviously it's less efficient. Next slide. Now, regardless of whether you have a delay claim or disruption claim or have both claims, the contractor has to prove liability, causation, and damages. And you have the burden of proof. So you have to prove why either the contractor or the owner is liable. Like I was suggesting, if they didn't get permits, if there's some other reason that the design was horrible and you had to submit numerous RFIs, etc. And then you have to prove that element of liability caused you damages. Well, that's pretty easy if on a delay claim, because you're out there for an additional week and you have GCs of a certain amount of money, and usually the damages kind of flow from the liability. Next slide, please. Now, as everybody knows here on this call, these last 2 years have been crazy times during COVID. And you really have to look at your subcontract terms. You have to look at the incorporated prime contract terms. And let me stop there. If you sign a contract that incorporates the prime contract and you haven't been given a copy of the prime contract, that's your time to ask for the prime contract before you sign your subcontract. I've been doing this, as I said, since 1983, and I can't tell you how many times in representing a subcontractor, they have a problem, and I'll say to them, can you send me your subcontract, which then incorporates the prime contract and the prime contract? Well, we don't have it. Let me see if I can get it. Well, that's not the right time to get it. The right time to get it is before you sign the subcontract, and that incorporates those terms so you know what you're agreeing to. So that's my pontification on that issue. You have the impact of COVID-19 pandemic can cause issues, obviously unforeseen supply chain disruptions, Resulting effects may be considered. And then you have to look at your contract. What does your force majeure clause say? What does your delay clause say? What are your change in law clause, suspension, cost escalation, and other applicable events? Now, some contracts, some subcontracts won't have any of those kind of clauses in the subcontract, and you may be able to take advantage of the force majeure clause that's in the prime contract. But you have to look, or you have to have your attorney look at those different clauses and see whether you can bring a claim when you bid a job one way and then you had to bill it another way. And subcontractors may be able to use these clauses, or if you don't have these clauses, if you haven't negotiated some of these clauses in your contract up front, then you have to argue commercial impracticability or frustration of purpose or impossibility of performance defenses. Now, those are legal theories to try to get your money back, but they're not as good as obviously having a clause on the issue. And I'll tell you a war story on that. Back when the Arizona Cardinals were building their stadium, I represented one of the steel subcontractors on the project. And back then, as some of you that have been in the business for a long time, you'll recall that steel prices just went through the roof at that time. Well, nobody had escalation clauses in their contract at that time, or any other kind of contract provision that was helpful. And so we had to argue, I'm in there arguing on behalf of the subcontractor with the general and with the owner. And we had, I had these theories: commercial impracticability, frustration of purpose, because the steel prices had gone up 40, 50%, maybe even more at some points. And, I didn't have much leverage because I didn't have a clause, but I was able, it was say $1 million claim. I'm just roughing out numbers now. And we got a little bit the way there, maybe we had $300,000-$400,000 on the table being offered to my subcontractor. And, I needed some way to bridge the gap. So I talked to Michael Bidwell, who's the owner of the Cardinals, who was at the mediation. And I said, any chance you could throw in a suite for 10 years or 5 years? I can't remember the exact terms, and some tickets to this. And that's how we bridged the gap. And he was willing to do that. And I ran into him a couple of years ago, and he said, "You look familiar." And I said, yeah. I said, I'm the one that shook you down for some tickets on the Cardinal Stadium in a suite. And he said, "That's okay." They renewed their tickets. So it was a win-win. But I mean, the whole point of this war story is to show how creative you have to get if you don't have much leverage. But if we'd have had an escalation clause, it'd have been much simpler. Next slide. Again, force majeure and COVID-19, as some prime contractors have force majeure clauses, which are helpful. Usually force majeure clauses give you extensions of time, but do not give you your GCs. So it'd be better if you had either a force majeure clause that had GCs, or had some other clause that gave you your GCs. You'd be protected from liquidated or actual damages arising out of the delays, because you're given a time extension, but you have to bear your own cost for your GCs. And because this COVID, as you know, is unprecedented and is still an ongoing issue, you should consider closely reviewing and updating your contracts with regard to provisions that are favorable, and get rid of the ones that are unfavorable. General conditions, I saw that question go up there. That's what GCs mean, general conditions, which are your cost of your staff that's out on the project, the fencing, whatever you have on the project. If you have, a project superintendent out there, obviously you wouldn't have them out there working if you were done with the project. And so those constitute GCs. I saw that question pop up. Okay, next slide, please. So on delay claims, you have to think of 4 different things. Is it excusable? Like in a force majeure clause, it may be excusable, but it may not be compensable, meaning you're going to get paid money. And it has to be something on the critical path for it to be a delay claim. The way I explain critical path to folks is, we just had Thanksgiving here a little bit ago. What's on the critical path if you want to have Thanksgiving dinner at 4 o'clock? What's on the critical path is getting the turkey in the oven. You can make the mashed potatoes and the other stuff later, but what's on the critical path is getting that turkey in the oven. So as most of you folks know, there's a critical path that goes through the project, and there's a critical path that goes through your work. And if you've just been delayed, but it's not something on the critical path, you're not going to be entitled to a time extension or to compensation. And then concurrency. There's usually, concurrency means that the owner or the general contractor caused you to be delayed. However, because one of your machines broke down, you wouldn't have been able to work anyway. So you delayed the project concurrently with the owner and the general contractor delaying the project. And usually subcontracts or prime contracts will have clauses in that address concurrency. And a lot of them say if it's a concurrent delay, it's not excusable or it's not compensable, or it may say it's excusable but not compensable. But you have to look at concurrency. Next slide. Excusable. I talked about this. A delay is excusable when it's due to unforeseeable causes beyond the control and without the fault and negligence of the contractor. So as I say, an excusable delay could be what Ed was referring to. I mean, in his opening remarks, if you're in the middle of a blizzard and you can't get out there and work, that's an unforeseeable cause beyond your control and without your fault. So it's excusable. It may not be compensable, but that's what's meant by excusable. Next slide, please. Critical. To obtain a time extension or additional compensation for extended delay, the delay must affect overall project completion. The delay must be critical. In other words, it has to be on the critical path or on your critical path for your work. That this is the way you intended to do the work. And that gets me to another subject that's not up here, and that is, when you bid a job, you ought to bid a job so that you have a schedule, a way you intend to do the work, and a price that's based on that schedule. And when you bid the work to the general contractor, you should always, if you can, and ASA has forms like this, you should condition your bid on using, say, a consensus doc, which is one of the more fairer subcontracts, and not getting basically forced to sign some contract with the prime contractor that just hammers you. And so one of the things you should do when you bid a job is you should bid it contingent on a certain contract form being used. And like I said, ASA has, if you go to their website, they have these kind of forms that are called conditional bid forms that you can use. And you want to be able to show somebody later, I bid the work this way, and my dollars are attached to that schedule. And now you're forcing me off of that schedule, and now I'm entitled to additional dollars or additional time. Next slide, please. Delays caused by material shortages. If I asked how many of you folks have been delayed by material shortages in the last year and a half, probably 75% of the lights on this webinar would go off. You're facing unprecedented price escalation and material shortages. As folks know, lumber has gone up crazy and all other kind of commodities. Now, depending on the length and type of shortage and the terms of the contract, including cost escalation clauses, these delays and cost escalation may be compensable with time or money, depending on foreseeability, impact, and the specific contract terms. Now, one of the things you should watch out for, and you may want to figure out how to address or discuss with your attorney, is if there's a no damages for delay or disruption clause, you may want to either strike it or figure out whether it's enforceable in your jurisdiction and that sort of stuff. But you don't want to incur all these damages for delay or disruption and they all get wiped out by a no damages for delay or disruption clause that's in your either in your subcontract or is in the prime contract that the general agreed to with the owner and that was incorporated by reference in your subcontract. Next slide, please. As I was saying, the consensus docs are, the reason it's called consensus docs, it was a consensus of subcontractors and generals and owners and folks got together and said, look, we're tired of paying lawyers to negotiate subcontracts and general contracts over and over again, et cetera. Can we just come up with a more fair starting point? I'm not saying that you shouldn't still negotiate if you have a consensus doc, but what I'm saying is the issues will probably be much more limited about what you negotiate over. But a consensus docs 200.1 is a new time and price impacted materials contract amendment that came out here in light of COVID and all the cost escalation that has occurred here recently. In this form or amendment, it identifies potentially time and price impacted material. For instance, lumber or concrete, whatever it is. It identifies a baseline price and it provides for an equitable adjustment to the contract price upon timely notice and substantiation of the increase. And it caps the percentage of adjustment. And an important provision in this amendment is that there's no contractor liability for delay in delivery that's not the fault of the contractor. Now, let's go to the next slide. And this is,
excuse me, Jim, there is a question asking what you're meaning when you say GCs.
GCs are general conditions. That's what you put in your bid to cover the cost of your superintendent that's at the site. You know, if you have fencing around your area, things that you have to bring to the site that are based on the time that's out there. You know, porta-johns, fencing, all that kind of, you know, your folks, your project superintendent, those are all part of your general conditions. And general conditions are GCs is a shortcut for general conditions. I hope I answered that. Going back now to the and keep bothering me and asking me questions. I just want to say bother. Please interrupt me and ask questions because I'm here to help you folks understand these issues and not to just go through slides that you could go through later if you need to. So this consensus 200.1, you see what's highlighted there. This amendment provides for a fair allocation of risk of such market conditions between the owner and contractor and shall only apply to the potentially time and price impacted materials listed in Schedule A to this amendment. And that's where you come in. You tell the general contractor, hey, the lumber that I'm buying ought to be one of the price impacted materials listed in Schedule A to the amendment. And you'll see under 2.1, what's highlighted, compensation for any potentially time and price impacted material shall not be duplicated in any contingency amount. In other words, you can't have money in your contingency and then try to duplicate it with compensation for a price impacted material. You can't double dip is the point. And then you see on the last sentence, the word not says any adjustment in pricing for a potentially time and price impacted material shall not include any amount for overhead and profit. In other words, if something goes up from $100 to $150, you're entitled to the $50, and maybe not the $50. I'll explain that later. But you're entitled to some percentage of that amount going up, but you don't get your overhead and profit. You can't add your 15% overhead and profit on the 50 grand that it went up, because you have to eat that because they're eating the increase in the cost of the material, which is something that really nobody can control. So that's an important element. Then let's go to the next slide, please. And then you'll see here what is highlighted on this page. The contracted price shall not be adjusted by more than blank percent of the original contract price for the aggregate of the increase or decrease in the baseline price for the materials. Now, let me explain this now. This escalation can be like, it can run like this. The subcontractor shall be responsible for the first 10% increase in the contract price. So if it was 100, like I used, if it goes up to 110, you eat that 10%. I mean, that's one way it can be. This thing can be negotiated. Then if it goes up from 10 to say 50%, the contractor and passed on to the owner eats that 40% increase. And so under 3.3, it would say the contract price shall not be adjusted by more than 50% under that scenario of the original contract price for the aggregate. And then if it goes up to 70, 170, the contractors are going to wind up eating the amount greater than the 50% if 50% is in there. So it's balancing. It's much better than not having anything and the cost going up. You balance. You don't get your overhead and profit. You may have to eat the first 5 or 10% of the increase, and they will usually put a cap on it under 3.3. And then going down to the last sentence, which I think is very helpful, notwithstanding any other provision in the contract, the contractor shall not be liable to the owner for any expenses, losses, or damages arising from a delay in the delivery of a potentially time and price impacted material, not the fault of the contractor, its subcontractor, and the material suppliers. So that really helps you if you've entered into this consensus 200.1, that if you're delayed 30 days because something is coming from China and it doesn't get here, you don't have to, you will not be liable to the owner for that 30-day delay period. Next slide, please. And this is defenses to delay claims. The first one, notice. Almost every contract has delay provisions. I mean, with respect to delay provisions, require that you give notice within a certain time period. And some will say failure to give notice within 5 days or 10 days or 20 days or 21 days, whatever it says, means that you waive the claim. Now, in some jurisdictions, we have a case in Arizona that may help you get around that notice provision if the owner knows about it and was not prejudiced by the lack of notice. But you don't want to be paying me and Ed to fight over whether or not you're entitled to your delay claim because you failed to give notice. Just give the notice. When you do a subcontract, you should get yourself a cheat sheet and that says, I got to give notice within 5 days or 10 days or 21 days so that your superintendent and your project manager knows to give the notice that's required. I told you earlier, if it's not critical, you're not entitled to a delay claim. If it's concurrent, you might not be entitled to a delay claim. The other thing is, don't sign lien waivers that say you have been paid for everything that you furnished on the project through a certain date if you've been delayed and you're going to have a claim for things that have been furnished because you had to accelerate or whatever you had to do to accelerate. You had to pay a premium to get things there on time. Watch what you're signing on lien waivers. Watch what you're signing on pay apps, and watch what you're signing on change orders. Some change orders will say, sign, like a lot of times, you'll get the amount of money that you're looking for in the change order, but the change order will say 0 as the amount of days. Now, you don't want to have to come back and say, well, I was entitled to 5 days for this or 10 days for that. They're going to show you your change order and say, look, you signed this. It says 0. So watch what you're signing. Lien waivers, pay apps. Pay apps will say this pay app constitutes everything that I'm entitled to through a certain date. Well, if that's not the case, you need to change the language. I think this is where I turn over to Ed and Ed with it for a while.
I'm going to be talking about disruption claims as opposed to delay. But first, Jim, there's a question in the chat from Mr. Alvarez. It is, can you put a clause in the lien waiver for other cost? Is his question.
Well, lien waivers and the law of lien waivers is usually a function of state law. So different states may have different cases that have interpreted their lien waiver forms. Arizona has a form that says it has to be substantially similar to the form that's in the statute. So in Arizona, you could carve out something and say this lien waiver has no effect whatsoever with respect to X, Y, and Z. And you definitely want to put that on your lien waiver form before you sign it.
Thanks, Jim.
Okay.
I'll be taking it from here to talk about mostly disruption, and then Jim will wrap up here shortly. So as I mentioned, my name is Ed Hermes. I'm also an attorney at Snell & Wilmer. And yes, the former mascot, as Jim mentioned. Thanks, Jim. I usually mention that with more of a home crowd of Phoenicians who get excited about things like that. Unlike delay claims, I'm going to be talking about disruption claims, which in a disruption claim, it's irrelevant whether the impacted activities lie on the critical path. As Jim mentioned, in a delay, you have to show that delay is on the critical path. He used an example of permit that didn't get issued. With disruption, what disruption is focused on is that loss of productivity. Oftentimes there is a loss of productivity that's a consequence of delay, not always, but regardless of whether the work is on the critical path, there can be a disruption claim for that loss of productivity. So it's a disruption claim is a loss of productivity for unanticipated increases in costs incurred to perform any given work activity. And I'll give you some examples. This is going to be going back to my old days of being a high school civics teacher. Always like to give examples to try to drive the point home. And some real world examples that we saw out there and are still seeing as a result of COVID-19. So, for example, you might have a regulation on the job site, whether it be a municipal, county, state, or job site regulation that says because of COVID-19, you can only put so many people, so many workers in a elevator. You're working on a tower that's 25 stories tall. Your guys got to get up to the 20th floor to do their work, but you can only put 2 people on an elevator at any given time, and that forms a line for the elevator, and folks have to be on the job site and wait an hour each time they want to get up to the floor they have to do work on. Well, to do the same amount of work, it's going to take longer. It's going to take more days. It's going to take more time to do the same amount of work. And if that, assuming that contract was signed pre-pandemic, for example, that would be probably an unanticipated disruption, and unanticipated additional cost that you have to incur to do the same amount of work. We're seeing a lot of, right now, with the delays and the issues with the labor market and material delays, we're seeing impacts on subcontractors who, are getting orders to speed up certain work or take work out of order than what was planned from the get-go. So maybe where your trade was planning to, paint after at the very end of the project, well, maybe that has to be done before all the plumbing goes in or before the sprinklers get done. And there's additional work that has to be done, taping things off or just working around other trades that causes an increased cost. A lot of times, or right now with the pandemic, owners and general contractors are making decisions to say, you know what, we're going to do work out of sequence to try to keep this project on track, and rather than shut something down or we're going to ask our subcontractors to do the work and just do it as best they can. Well, that's going to cause usually that's going to cause a disruption. It's very important, as we're talking about here, to document that loss of productivity, that loss of output that's caused by these unforeseen situations. All right, let's talk about the elements for a disruption claim. Like a delay claim, the elements are liability, who's responsible for it, causation, and damages. We'll talk a little bit about those elements, what that means, and then what is the best way to set up and really document a disruption claim. So liability, that's impacts due to errors and omissions in design documents. Who's responsible for those things? Of course, under the Spearman doctrine, the owner, if it's a design bid build, the owner's responsible for it. If the owner contracted for that design, the owner's responsible for those errors and omissions in the design documents. If there are errors and omissions that cause a disruption to you as the subcontractor. Impacts caused by having to perform work on a sequence. We talked a bit about that. Delays which push the project into periods of adverse weather conditions. So if there's a delay that, if your project, you're in wonderful Minneapolis, wonderful place. I just got back from visiting my sister there, and your job is supposed to be done in the summertime when the weather's nice, but the permit doesn't come through, or there's a delay that pushes your work into the wintertime. Well, your employees, your workers are not going to be as efficient swinging a hammer, in a snowstorm in December as they would be in, a beautiful August sunny day in Minneapolis. That's going to cause a disruption and an increased cost of doing the same amount of work. Another example would be effect of excessive overtime due to acceleration. We're seeing, like I mentioned, a lot of acceleration happening, being pushed down to trades for general contractors trying to keep a job done on time. And, general contractors saying, you're going to need to work through the weekend, or you're going to need to pull a double shift or get your folks doing overtime. There's numerous studies that show that workers are not as efficient if they're working an 18-hour day versus an 8-hour day in an hour per hour, that efficiency goes down over time. What is the cost of that? There's going to be some impacts of that acceleration typically, and some increased costs due to those disruptions. Very important to document those things to prove up your disruption claim, which we'll talk a bit about. Causation. Was the event unforeseeable at the time of the subcontract or change order execution? So, is the event that occurred that caused the increased cost or caused the the slowdown or the disruption, was that something that was foreseeable? A lot of the jobs now, if they're newer jobs, we've been in this pandemic now for coming up on 2 years really, where people have known about this and the potential effects. A lot of times those contracts nowadays are going to address those potential delays, or at least that is something that is foreseeable. It's harder to argue the unforeseeability depending on the type of disruption with a contract that was done after the advent of COVID-19. But there's new and nuanced disruptions that are happening all the time due to material shortages. So really looking at, was that thing that caused the disruption, was that unforeseeable at the time? We all know in Minneapolis it's going to be cold in December, but what we don't know, or what would likely be unforeseeable, is here in Arizona when this has happened before, we get hurricane-like weather in southern Arizona, or hurricane to the south of us that has an effect on a job site that completely washes out or disrupts the job site. That's something that would likely be an unforeseeable event. Events were beyond the claimant's control, so it's not something that the subcontractor had control over. Events were caused by owner or design professionals in a design bid build project, where of course the owner or design professional would have responsibility in a design bid build. Of course, in a design build contract, that's something that the general contractor would take responsibility or have responsibility over the design in that scenario. So from a subcontractor perspective, it still would be out if there's a problem with the design that the subcontractor had no responsibility for. That would still be outside of your control and a potential disruption claim, regardless of whether it's a design bid build or a design build contract, as long as you're not responsible for the design, which would be very rare. Events were caused by situations for which the owner assumed contractual liability, such as force majeure or differing site conditions, which we talked a bit about force majeure before. Let's talk about damages. It's important to note that in a disruption claim, damages can be difficult to prove. How do you measure when your workers have to wait in line and can't, for the elevator, for example? I'll give you another example that can be illustrative as well. There was a job here in Arizona that Jim and I have talked about many times before, where there was a noxious gas that was discovered on the site. There was some underground boring that had to happen. Well, those workers who had to do this work underground then had to wear full hazmat suits with limited visibility while they're doing their work underground. That was not something that was known or foreseen when the subcontract was executed, but it was something that had to be done for employee safety. As you can imagine, wearing a full hazmat suit with limited vision is going to slow down and going to affect those folks' productivity. Very quintessential disruption claim there. Well, how do you measure that? We'll look at a few different ways. That is important to measure and record and document that loss of productivity. In preparing this presentation, Jim and I spoke to different folks in the industry, owners and general contractors, and kind of solicited, try to get a sense of what people are seeing out there. And one of the things that I heard from folks is that owners and general contractors can be very wary or skeptical about disruption claims because they can be hard to prove in terms of damages. A lot of times owners will just say, well, you should have been more, you should have handled the job differently, or you should have been, more efficient, or had more or had fewer, usually more, folks on the job, and that's your own fault, and you didn't provide the proper oversight. So there's a lot of skepticism that can come with disruption claims, which makes it very important to document in real time as these disruptions are happening, or even before, if you're learning about them, to document and record in real time what real world effects those disruptions are having. So damages, if it's your disruption claim, you've got the burden to present and a reasonably accurate estimate of those losses. It's not necessary to provide a precise calculation, but you must utilize a methodology recognized by courts or arbitrators. You're going to want to start with your job cost report. As Jim mentioned, COVID-19 pandemic and other factors have caused global disruptions to the supply chains and labor markets, and caused a lot of folks on the job site to make difficult decisions of how to proceed. Like I mentioned before, owners and contractors, instead of accepting that an unforeseen disruptive event has necessitated a work stoppage, owner or general contractor might try to push through, instruct the subcontractor to proceed, try to be as efficient as possible, and try to work around those impediments. Those impediments, whatever those might be, are likely, you do your best, but they're still going to oftentimes cause a loss of productivity. It's important to convey as soon as possible and provide notice to the general contractor that those changes are going to cause a loss of productivity. Doing so in your written communications, your emails, your dailies, your job cost reports, and doing that as contemporaneously as possible with knowing about that unforeseen activity that causes the disruption. Jim here on the call can tell you he serves as an arbitrator all the time in these type of claims, and that evidence of contemporaneous notice and what's happening on the job site at that time in your dailies or your emails that are happening back while the job is being done, that is very impactful evidence in any sort of claim or arbitration that might happen. A lot of times arbitrators and courts are going to want to see that, and they're going to find that type of evidence more trustworthy than statements, or at least more impactful than statements that happen, a year later. Proving disruption damages, I mentioned that it has to be done through an accepted methodology to show those damages. Here's a few. The actual cost method, proving up what the actual cost is caused by that disruption, the measured mile. Good example, in that claim we talked about, the underground boring that happened in the hazmat suits. Well, you can take what it was supposed to cost per foot or per yard or per mile for that underground boring, and then measure that by what it actually cost to do it with a hazmat suit, and compare those to understand what those disruption damages are. We call that the measured mile. Similar work comparison, comparing similar work done with and without that disruption, and what the delta is for that to understand what the disruption damages are. Looking at specialty work, industry studies, general industry studies, and the total cost method. Oftentimes, especially with the total cost method, you're going to need to have expert testimony to prove up what that total cost is with and without that disruption, to prove the damage is sufficient to satisfy an arbitrator or a court. Defenses to disruption claims. Notice, Jim touched on this a little bit. The contract typically is going to say if there's a disruption in some unforeseen event that causes an increase in your costs or loss of productivity, you've got to let the general contractor know within a certain amount of time. If you don't, you don't know your contract in that way, it could lead to a waiver of those increased damages. There are some defenses of that, and potential ways around those clauses based on your state and based on your case law. But as Jim mentioned, you don't want to have to pay an attorney to try to track those down when you have the contract, can make that little cheat sheet and understand the deadlines to provide that notice of any sort of increased costs or disruptions on the job site. Other defenses to a disruption claim: job cost report, lien waiver language, pay app language, change order language. You don't want to be signing things or submitting reports that say there are no disruptions, or there is no increased costs, or we don't have any claims for increased costs during a certain period when you do have those. We see it all the time where at the end of a job, when maybe the owner's upset because there was a delay and they're trying to push down liquidated damages, LDs, or there's other claims swirling around between the owner and the general contractor, and the general contractor trying to push claims down to the subs. And then the subcontractor says, oh, hold on, we had increased costs because of X, Y, and Z, a storm hit. One of the first things that Jim and I look at is, what did you sign in your change orders, your pay apps, your lien waivers, and is there an issue with waiving those potential claims in any of those documents that were signed? So pay close attention to those as well. Okay. Tips for delay and disruption claims and overview. With these elements in mind, here's some common keys to try to set up your claim as best as possible. A few of these are a bit of a recap. Know your subcontract, the key terms related to delays and disruption. Provide information to plan that project so you can plan it from the outset. You're not behind the 8 ball before you even start swinging a hammer. Follow the subcontract and the plan, and document. Properly document, communicate those notices, those dailies, those meeting minutes, those scheduling updates based on what's happening on the project and the delays and the disruption that you're encountering on that project. And diagnose the delay and productivity impacts early. One of the things that we often hear, or at least I often hear from owners and general contractors is, hey, had they told me that they were encountering this, we could have tried to solve it together. But I didn't know about it, and now you're telling me about it 6 months after the fact, and I'm not going to pay the claim because maybe we could have been avoided had you brought this to my attention earlier. So diagnosing those claims and providing that notice early to your general contractor so you can put your heads together is going to be very appreciated and going to help set up your claim as best as possible. I'm going to go ahead and kick it back to Jim to bring us home here.
Okay, thanks, Ed. Let's talk about some of the tips for delay and disruption claims. A subcontractor's claim can be doomed by, number one, you didn't have a good plan to start with, and somebody will come back and say, well, your plan and your bid didn't make any sense. You needed more horsepower to get this thing done. It can be doomed by your subcontract terms, or it could be doomed by not following the subcontract and not giving the notice provisions that you were supposed to. Next slide, please. Now, here's your key contractual provisions. What is the definition of substantial completion and time? In other words, a lot of times you can't bill for retention until you reach substantial completion. And for time extensions, what does the contract say about time extension? What does the contract say about the date of commencement? You think this is kind of silly, but I have people that say this project commences on the day that the contract is executed, and then the owner doesn't get the permits for 3 weeks, and then they say, well, your contract time started on the date of commencement. Well, you signed it. You should have not signed it and agreed to the date of commencement or the obtaining of all necessary permits, whichever is later. just that saves you maybe 3 weeks of a delay claim. Scheduling, you got to have a critical path method usually to prove that you had a critical path and that it was impacted. Claim provisions for delays, unexcused versus excused delays. In other words, look at what the contract says about all these things. Claim provisions for delay, concurrent delays, no damages for delay or disruption clauses. Next slide. Know the contract. Is there any favorable law? Know what's in the GC's contract and the subcontract. Provisions relative to the scheduled work. When can you seek relief for changes and impacts upon your work plan? Notice and claim provisions. We talked about no damages for delay clauses and how they can harpoon your claim. And consider negotiating harmful terms and conditions away. Get rid of them up front so you're not paying lawyers to fight over them later. Obtain a copy of the contract, subcontract, and understand the obligations before bidding or contracting. And then here's the other thing. Is there any favorable law? Prompt Pay Act. Do you have a Prompt Pay Act in your statute, in your jurisdiction that trumps what's in the contract? Is the pay if paid clause in your contract enforceable? Some places it is, some places it isn't. Is the indemnity clause enforceable? So just because something is in the contract doesn't mean that it's enforceable. For instance, I had a claim this was on behalf of a general contractor against an owner that the contractor called me up and said, hey, I just got hired here. I think this claim is too late. It says that if you have a claim against the owner went belly up, but the owner had a surety, but it says that any claim against the surety has to be brought within a year. Well, we did some digging around. We found out that there is law that says that surety is considered an insurance contract, and then there was a statute that says any claim on an insurance contract has to be brought within 2 years. And so all at once, a claim that the contractor thought was worthless, I wound up with a $800,000, somewhere in that neighborhood, settlement on the claim. So before you throw something away or before you throw up your hands, you may want to see whether there's some favorable law on the issue. The next slide, please. Scheduling issues and delays. Obviously, labor shortages and material supply issues can trigger chain reactions causing delays or disruption. If they try to hold you to the same substantial completion date, then you have stacking of the trades. That can cause inefficiency and disruption. When providing input into your schedule up front, in this market and with COVID, consider scheduling in more float days for inevitable delays and likely delays in obtaining permits from municipalities, because they got people that are working from home and aren't working as much, or when developing or modifying the schedule. In other words, put some float in there for yourself. Next slide, please. Key considerations. Review the subcontract language. Review daily reports. Daily reports, as an arbitrator, I give those a lot of weight because it's not somebody concocting some story after the fact. This is the daily reports as they happen. I know at the end of the day you're tired, but review the daily reports. Do good daily reports that address labor and other resource utilization, etc. Give written notice. Put things in your meeting minutes. If the general contractor writes up the meeting minutes or the owner, look at them and make sure they're accurate. And if they're not accurate, then change them right away. Follow up in a timely manner and as required by the contract to present a quantification of time or money sought as relief. Next slide, please. Consider the evidence. Explain deviations from the work plan in contemporaneous project records. What I'm saying is, we bid the job for $2.5 million or $250,000. And we agreed to do it this way, but this disrupted us. And don't just write things down, take photos, take videos, because, you know, a picture's worth 1,000 words. This is usually the most persuasive evidence. Track your cost. Get somebody in your finance department to basically track the cost separately, so that at the end you're not saying, well, I expected this job to cost me 1.8 million, it cost me 1.9, so I want $100,000. Well, that total cost method is not liked by the courts, because they could say, well, you might have underbid it or this or that or the other. So track things with a specific code and track the damages. Next slide, please. Cumulative impact claims. This is the old, and you probably see this more often now, but it's the old death by 1,000 cuts. And that's when you just get change ordered to death. I mean, you're going here, you're going there, then they change the plan, and you're in the middle of fixing one thing, and then another change order comes in. Well, there's a concept called cumulative impact, and that's where there's multiple changes on a project, and they act in a sequence or concurrently, and it's like a compounding effect. This is the most damaging consequence for a project and the most difficult to understand, manage, and prove. You have one of these things, I recommend you get good counsel, and then your counsel will find a good expert that can help put this thing together. The net effect of the individual changes is much greater than the sum of the individual parts. In other words, you folks probably know this more than I do, but when the project requires multiple change orders, there's a corresponding ripple effect. You may be required to tear out work that was already in place, or replan and resequence work that had previously been scheduled. You have to adjust your manpower, put them over here, put them over there, have them work overtime. They're not as efficient, as Ed said, when they're working, 70 hours a week versus 40 hours a week. So this is one of the last slides we have, but cumulative impacts, when all else fails, if you have one of these jobs that have, hundreds and hundreds of change orders that affect, of which most of them affect your work, you might have a cumulative impact claim. Next slide, please. So major causes of, your workflow disruption. As I said, you thought you were going to go to the second floor, you wind up on the 20th floor. You're having to build things out of sequence. There's a lack of materials now. You plan to do something, the materials don't come in. You got to have a new work plan. The same work but different conditions. You're doing the same work, but instead of 2 people being in the room, as I said, you got 10 people in the room tripping over each other and fighting over who gets access to what. You've all been there. Work performed in adverse weather conditions. Ed described that. Significant overtime. Ed described that. Next slide, please. Now, here's the common keys. Reserve the right to the claim. If you're getting change ordered to death, and you have, this change order is only going to entitle you to a 3-day delay, and this one is going to, is going to entitle you to a 2-day delay. But you have hundreds of these things. The cumulative impact might be more than the 2 or the 3 days, or you put down 0, 0, 0, 0, 0. But after you get 20 of these, it's really not 0. The cumulative impact of those 20 change orders may be, 2 weeks or whatever. Be prepared with evidence to support that the changes were excessive. This isn't a case where every project has change orders, but this is where you say, man, I've never been in something like this. Be prepared to demonstrate the link between excessive change orders and the loss of productivity. This is, like I said, difficult, but it's important. You got the burden of proof. Observe and document the ripple effect as changes are executed. We intended to work on the 3rd floor today. At 11 o'clock, they moved us up to the 20th floor. We got started on the 20th floor. At 3 o'clock, they moved us somewhere else. And as I said at the end, you're probably going to need legal and consultant help on a cumulative impact claim. Next slide. There you go.
There we go.
We got any questions? We'll hang around here for another 5-10 minutes. If anybody has any questions, we can do them. You folks that stayed, and I appreciate you staying to the end. I know we went over 5 minutes, but I told Jessica that we would hang around till 1:15 Eastern time to answer any questions. So if anybody has any questions, now's the time.
Great. In the meantime, thank you, gentlemen, for your presentation. Thank you, everyone, for joining us today. Again, this recording will be on the ASA online website, and we also have a copy of the slides from the presentation that you'll be able to see as well. So with that, I'm monitoring the chat box. I'm not seeing anything come in, but get your questions in if you have any questions for Jim and Ed.
Yeah, we'll hang around for 2 or 3 minutes. If no questions come in, we'll call it a day. And best of luck to all you. Thanks for hanging in there with us. And if you'll probably see us, we do presentations once or twice a year, usually for ASA. So you might see us down the road. I think everybody is exiting.
I think, oh, looks like we've got one. Okay. In the event of multiple change orders with delays, would it be possible for the GC to state these delays could have been worked simultaneously?
Well, the GC can make that claim, but you bid the job with a certain workforce and a certain plan. You put your dollars in with that workforce. Sure, you could have done multiple people and paid them overtime, but if you paid them overtime, that wasn't in your initial plan, and therefore you should be entitled to the additional dollars. The GC can't just come in and say, well, you could have done this. If you could have done it with your original plan, but you had some of your equipment break down, or some of your folks decided that they were going to make more money across the street and left you, then the GC has, and now when I say GC, I mean general contractor, has a point. But that's why it's so important to, when you bid the job, show people this was my plan and my dollars were allocated according to this plan. And if they make you deviate from the plan, then you got a probable claim. Anything else? Here's some thank yous. Thank you.
Thanks, Scott.
Okay, with that, I think we will go ahead and conclude for today. So again, thank you, gentlemen, very much, and we look forward to everyone joining us on the next ASA webinar.
Thank you.
Looking forward to it. Thank you.
Jessica.
Thank you.
Okay, bye-bye.